Great. So what, criminalizing China, what am I talking about here? And in particular, I'm looking at the Department of Justice's China initiative. So this was it's an ongoing initiative. It started in November of 2018. Then Attorney General Jeff Sessions stood up the microphone, flanked by members of the Department of Justice, and announced that what was already a pretty large-scale effort to look at particularly economic espionage, but other intellectual property thefts and other criminal offenses that were linked to the PRC party state. And this was the time, too, where a couple of big indictments came down, one of which involved Tappy the robot, the stealing of the T-Mobile robot arm. And this consolidated what was already ongoing concerns about IP theft. And in fact, I need to put in a little plug. Next Wednesday, SUP China is hosting a US-China series, and I'll be on a panel talking about some of these issues with not just one of the people is Mara Histendal, who is the author of the recent book, The Scientist and the Spy, which goes into detail to one of these cases from during the Obama era that involved the theft of corn seeds that had great value to Monsanto. So it's not to say that 2018 was a new idea that there was IP theft and it was connected to China, but rather a shift in how it was being dealt with and putting it under this framing of the China initiative and devoting greater resources and effort to this. So where I came at this was as someone who not only, of course, studies China, but teaches and writes in US criminal law and criminal procedure. So this was an interesting announcement. I was following it, and then I became even more concerned about this framing. First, when in November of 2019, the U.S. Attorney's Office in New Jersey, where I have friends and there's lots of great people, but they came to Seton Hall because as part of the China initiative, there was a push to do these threat awareness briefings where members of DOJ, both the prosecutors, but also FBI agents, will go and talk to academics, but also the public. And particularly being in New Jersey and having a lot of ties to the big pharmaceutical companies, that was an audience that DOJ really wanted to connect with. And so in coming to Seton Hall, I offered to be on the panel. And it was really interesting to see the PowerPoint presentation, sort of how the people working on this initiative and the inside were showing their work and talking about things like how they saw the Made in China 2025 plan by the PRC government as the sort of invitation to engage in IP theft. A lot of concern about non-traditional collectors, as they call them. So not just sort of your old school John le Carré spies, but much more recruiting people who were in business, in academia, to act as arms of the PRC party state. And I saw that, and then in February, early February, there was a conference at the Center for Strategic and International Studies on the China initiative that had even now Attorney General Barr speaking and seeing how the rhetoric was even more ramped up. Things like showing a diagram, sort of a circle with different aspects of what is perceived as Beijing's ambitions with respect to different kinds of technologies. And one of the members of the Department of Justice calling this the Wheel of Doom, lots of emphasis on China as an existential threat. And, you know, so me being concerned about what does this mean for when prosecutions are being brought against individual people. And that when I look at the China initiative, of course, ultimately there are individuals being prosecuted and punished. And the standards have not changed that the Department of Justice needs to prove every element of a crime beyond a reasonable doubt. It's not watering that down. But what I am concerned about is first how China of the China initiative becomes, I think, an over-inclusive conception of the threat. And then secondly, what I address in the part 4 of this paper is saying, well, normally when prosecutors are making a decision whether to prosecute, and then we have federal judge, at least one here, that the federal sentencing guidelines then say when punishment is determined, we think about certain basic principles of punishment: deterrence, incapacitation, rehabilitation, retribution. And to what extent does framing this initiative as the China initiative further those goals, or, as I argue, work in tension with them? So that's where I start with. And so I want to also make clear that two things. First, I don't think the Department of Justice is making up a threat. I totally agree that there is overwhelming evidence that people connected somehow with the PRC party state are engaging in intellectual property theft and other illegal activities in the United States or outside the United States that there would be jurisdiction in the US. So I don't think they're making up a threat. I think the way it's being responded to could be done in a better way. And second, I also think it's important to emphasize that this is really an ongoing initiative. So first of all, that in February, representatives of the FBI said that there are approximately 1,000 investigations across the United States right now. So there's a lot of cases in the pipeline. Not every one of those, of course, will result in a prosecution. There's a lot of attrition, but this is something that is very much happening now. And in fact, there was a Politico article that was published earlier this month, and so written probably when COVID was just heating up. But in that article, John Demers, who's the Assistant Attorney General for National Security, is quoted as saying that he wants each of the 94 US attorneys districts to bring cases under the China initiative. And it's not a direct quota system. He says some of them might take longer, it might not be one each district, but I always get worried when I hear anything that starts to resemble sounding like there is a quota system for prosecutors. But that's all to say the momentum is there. So so the first part of my argument is really about, well, what is the China of the China initiative? And you hear a lot in the rhetoric from like FBI Director Christopher Wray, as well as Demers and others that are higher up in the China initiative, about a China threat and what is this threat. And I think it conflates a couple of different things. So of course, part of it is the PRC party state, and that is the node and what the focus should be. What is the leadership in Beijing, and it being a party state, of course, not just the formal government, but how the Communist Party plays into it. And that should be the focus of the concern. What is being directed by the PRC leadership? And what I find interesting here is that there is an understanding to a certain extent when I read the materials around the China initiative that it needs to be understood as the party state, right? Not just the formal government. But I get concerned that there are a number of times that you hear the public statements by members of DOJ saying, well, do we want the world to go through the United States or communist China, or the threat of communist China? And of course, the CCP is technically the Communist Party. However, the way that communist is emphasized, it makes it more of an othering and has echoes of some of the old school Red Scare. So I don't think that's particularly helpful. So anyway, so part of this China of the China initiative is the PRC party state, but it also encompasses people who have either PRC nationality currently or PRC national origin. And there's a lot of discussion about how the PRC party state could kind of pull the nationality strings or pull the heartstrings of people who are connected to the PRC and use that as a way to leverage them and turn them into these non-traditional collectors. So sort of encompassing people who have those nationality ties as part of the threat. Another part of the China threat even extends to the way ethnicity is discussed. And I think sometimes this is partially just because when you say Chinese in English, sometimes it's not clear whether you mean Chinese nationality or Chinese ethnicity. But there also, again, is this discussion about people who have ethnic ties or sort of heritage ties to the PRC are seen as being more susceptible to the influence of being turned into these collectors, into these non-traditional collectors. Now, everyone, I'm sure most people on this call know that, just because someone, of course, has ethnicity that is Han Chinese or otherwise an ethnicity that is currently represented in a large proportion in the PRC doesn't make it so they'd be friends of Beijing. I have plenty of friends in Taiwan who would be very averse. But for example, there's quotes from Lelling, so Andrew Lelling, who is the U.S. Attorney for Boston, and talking about, well, yeah, we're looking at Han Chinese because there's more Han Chinese that are connected to the PRC. So if we're interested in French espionage, we'll be looking at Frenchmen. So there's a discussion too about being Han Chinese or ethnically Chinese as something that also raises this concern that the person is a threat. And finally, too, when I look at the talk and the writing around the China initiative, the government also seems to be bringing in people who have what I call acquired China-ness, have somehow built ties with China that can be suspect. So for example, a couple of the press releases that talk about indictments under the China initiative are for people who are white guys, generally. I don't know if there's white women, but then we'll note like, but they speak Chinese. Or we've had students at like Yenching Academy been visited by the FBI when they returned from their studies in China to ask about their experiences. There's threat awareness films that talk about, for example, the Game of Pawns, which if you Google Game of Pawns, the Glenn Duffy story, it's kind of an interesting watch, which is an FBI production, but it's a dramatization of the story of a white guy from the US who studied abroad and was approached by PRC operatives in the government and subsequently sort of co-opted. And this is put out there as making people aware of the threat that they too, if they are studying in China, could be prone to this kind of co-optation. So all this gets kind of wops together under this umbrella of China. So 2 points before I just finish up with talking about the purposes of punishment quickly, that throughout this rhetoric, there are these interspersed comments by members of the Department of Justice saying things like, but we're not against the Chinese people in general. We welcome the Chinese people. And I think it's important to point out that those sort of occasional comments don't work as an antidote. That doesn't take away what I see as this problematic, over-encompassing China threat narrative. And in part because if you've done any work with, with microaggressions or micro-invalidations, that if, for example, if someone's mansplaining to me, which happens sometimes, and then says, but I'm not sexist, that doesn't mean what they just said wasn't sexist. So similarly, for someone to frame their conversation in a way that is problematic because of the way they're talking about race or ethnicity, they don't then just get to say, no, but I'm not racist, or it's not because of your ethnicity. And in fact, that kind of invalidates the lived experience of a lot of people in the US today who are of Chinese heritage or even more generally Asian. And second, I think this has a lot to say, not just about the Department of Justice, but also about the more problematic climate for engagement with China in general, and how it's increasingly difficult to be someone who believes in engagement without being seen as sort of a panda hugger, or as I say, a panda helper. And that I would love to hear Jerry's thoughts, because I feel like sometimes we're kind of back in the era where only Nixon could build ties with China because he had established that he was tough on China first. So just finally, part 4 of the paper, and I'm happy to discuss this more in Q&A, but it gets a little bit more into the crim theory, that I understand that the point of Department of Justice is to deter. And deterrence is, of course, something we seek in the criminal law. I worry about over-deterrence, that a lot of good collaboration, a lot of good contacts could be cut off because of this. And we try generally with deterrence to hit the sweet spot and not deter too much. And that it's not just about the way the rhetoric is about deterring the individual sort of thieves and hackers, but the talk is China as an actor. And that the hope is that DOJ seems to think that by having these individual prosecutions, it will deter the central leadership in Beijing from encouraging people to engage in this kind of IP theft. And I'm skeptical about whether we'll achieve that deterrence. Incapacitation, I don't think that the justification of incapacitation is very strong here. Once someone is exposed as engaging in IP theft or for not disclosing their ties to China, they generally don't need to be locked up, that's for sure. What's more interesting to me is whether there could be over-incapacitation, again, similar to over-deterrence with China, and even the decoupling conversation, that this could encourage that building walls between the US and China that could actually hurt us in the long term. Rehabilitation, I don't see that being something that's talked about as a goal of this initiative, certainly not trying to rehabilitate people, especially if they're foreign citizens, because they would just be shipped out of the US if they had after a prison term, if they have one. And but there is still some talk about rehabilitating Beijing, and trying goes back to sort of that responsible stakeholder, that somehow, you know, we can get it so that Beijing and the leadership will respect IP more through this initiative. And finally, retribution. I think that this is really interesting to think about whether people who engage in IP theft and connected to China are seen as more culpable, either more morally culpable, or that they've created more harm than, let's say, they were helping out a Brazilian company or something. And there's also a lot of talk in this initiative about China's malign behavior, that China as an entity has done these blameworthy things. So last, what do I want? I want DOJ to ditch the name China Initiative. I think it does more harm than good. I think there needs to be a lot more substantive cooperation between academia and non-governmental experts and the people running this program. It's starting, but there's not enough. And I think there needs to be more training of people who are working on this initiative, more understanding of China and as far as like the PRC party state, even better training with respect to how to pronounce pinyin. As a matter of respect, learning how to say Chinese names even better would demonstrate that there's real effort being put in. So I'm gonna end there and hand it back to Jerry.
Well, that was a terrific presentation. And I suppose we could start with what you've just ended with, which is what can we do about it? Obviously, you're calling for an end to the initiative, but as you point out, the initiative in the Justice Department FBI context is only a part of the much broader US whole effort against China. And it raises this whole question about to what extent you can separate the framing of the question in a proper way for a criminal prosecution against an individual.
Jerry, we lost you. You're muted. You have to unmute. Somehow you got muted.
Oh.
There you go.
It raises the broader question of how do you separate the criminal prosecution of individuals with the usual protections from the broader US government policy toward China that the current administration has especially been advocating, which embraces questions of diplomacy, security, foreign policy, economics, military, etc. This is a much broader context, and how to insulate the prosecutions of individuals who ought to be prosecuted from this broader context is the challenge you're presenting us. And the question really is how to do it. It becomes more complicated, it seems to me, when we're talking about the prosecution of Chinese companies. And as you point out, it's even very complicated these days to know what is a Chinese company and what is a Chinese government party state-controlled company. And it seems to me this it warrants some discussion. And of course, this comes up in other contexts, and different standards have to be employed, as you indicate, if we determine should we use Huawei 5G equipment and the relationship of the Chinese government party state to Huawei company compared to the relationship to people who are charged with criminal punishment. So I think maybe we could start with talking about this and then move on to related questions, or continue if people, I always like to recognize, if I can, two fingers. We haven't started that yet with Zoom, but technology should permit it. I hope Don has found a way to register his desire to take part, because I look forward to it. But Maggie, what do you think?
Yep, I did.
Yeah.
Yes, good. What do you think about this attempt? You see, what you raise a broader question of political science, international relations. What is totalitarianism? You give a definition of totalitarianism that seems pretty strict in the sense, as long as there are some people in a country that still feel free to resist the pressure of the government, that you can't call it a totalitarian system. And does that embrace people who resist and then go to prison or otherwise punished for their resistance? I don't want to define totalitarianism so strictly that Nazi Germany or the USSR wouldn't qualify. So as a second question, after we get to the first, maybe you could talk a little bit more about where does totalitarianism fit in?
Yeah, no, and I do want to make sure not only Don, I'd love to get his thoughts on the companies, but I know Sophie Richardson is on, and I'd love to hear her thoughts because she's done a lot of work looking at academic freedom and connections to China and universities and whatnot. So when I get done, I'd love to get them in the conversation. So first, beginning with this idea of totalitarianism, I mean, it's something I just breeze through, and I agree, can stop and perhaps add more in the piece. It's an interesting question too, because I know Jerry has read the Washington Post piece that just came out looking at Matt Pottinger and his role in the U.S. government, and he of course had spent time in China. He was a reporter there. He had his own experiences being directly repressed and actually, kind of roughed up by state authorities. So his eyes are wide open. But one question with that, piece is what does a hardline approach mean? Because I think, regardless of whether we had a Democrat coming in next election or continue Trump, that it's going to be a hard line towards China, but parsing what that is. And I spent my career, in many ways criticizing the PRC government. I just said they should unsign the International Covenant on Civil Political Rights because of their terrible human rights record. But my point with respect to that phrase in totalitarianism was not to think about the exact definition, but rather that I get frustrated because I do think that even though, of course, the government and the party has a huge sway over just about any entity, whether it be a natural person or a legal person within China, there is still some space for pushback. So for example, if you get a company like Didi or Alibaba that wants to be taken seriously as a somewhat at least private company and operate abroad, they aren't just complete puppets of the party state. And I think that the rhetoric that comes out of the US government sometimes is simply because you have a Chinese name and you're based in China, that we can't have any separation in thinking about what your motives would be. And so I think that there just needs to be a little bit more nuance there. Huawei, though, I mean, and Don can speak to this, there's a lot of reasons, of course, to be very concerned that if Beijing and Xi Jinping said jump, they'd say how high. So that's, there is, of course, a threat again, but it just becomes overly simplified, I feel like, in the US government rhetoric. And so for this, and this what makes it hard because a lot of this is nuanced. So I bring up, for example, the unverified list and export control laws in the United States, and the unverified list being a step before the entity list, which really blocks off. And certainly if you have a sensitive technology that could have dual use military capabilities, there are very good reasons to be concerned about closely monitoring collaboration and conversations with those Chinese entities. But again, it's hard because it paints with a broad stroke. So like Renmin University, where we've done a lot of cooperation on criminal justice, the whole university gets put on the unverified list. And it makes it hard for there to be cooperation in areas that are nowhere touching any kind of what I would think is sensitive national security areas. And this is, sort of how can we get better about doing this sort of small yard, high fence approach, this phrase meaning figure out what we're really trying to protect in the United States, build a strong high wall around those, but try not to have the over-deterrence, the over-incapacitation, the just massive sweeping, we should decouple, Tom Cotton, we only want to let people come from China to study Shakespeare and not physics kind of approach, which I think will ultimately be to the US's detriment.
Good. Well, what about the question I started with? I'm very interested in, this comes up in another context I've been asked about several times this week, the context of suits people want to bring now against the Chinese government because of alleged negligence, et cetera, with respect to its failure to stop the coronavirus during the early days. And one question I get is, we hear a lot about sovereign immunity from suit of foreign governments under our relevant legislation. And then they say, what about the party? If we can't sue the government, can we sue the Communist Party? And that's a fascinating question that should interest the judges who were tuned in on this program, because they may have to be confronted by it. It raises your very good discussion of the extent to which the party and the government, the party and the state, are interlocked in China, and indeed whether the party controls the state. And it comes up, as you know, in Taiwan with the question of, should the Kuomintang, the Nationalist Party, be deemed an independent legal entity because it has possessed huge assets independent of the government, and yet under the Leninist principles practiced by Chiang Kai-shek, the party and the state under the Kuomintang in the era of Chiang Kai-shek and his son, certainly it was a party state despite democratic rhetoric, etc. Do you have any reaction to this?
Well, one thing with the Missouri case and others, which I find interesting, is if you're trying in the US to sue the party to get around sovereign immunity. And it makes me think of all the time we spent in China when we talk about administrative law, where you can sue the state, but you can't sue the party, you know? So it's sort of like, when does it help or when does it hurt what part can you sue? You know, I think, you know, a little plug too, there's a book coming out edited by Sue Travaskis and Roger, who I'm just gonna say Roger because I can't pronounce his name in Flemish, Crimeers, about the party and ideology. And I have a chapter in there where I'm trying to explain to people, you know, what is this relationship of the party and state? And, you know, I think of it, you know, as this double helix where you've got the party strand and the government strand, and they're connected by all these bridges. And of course the party is always dominant, but increasingly what we're seeing is now it's almost like, I say, an atom where you've got the party in the center and then the government bodies are becoming less and less important as Xi Jinping has put a lot of these, you know, leading small groups and created things like the National Supervision Commission that are morphing party and state entities into one, with the party aspect being dominant. So I think this is an evolving or perhaps devolving situation, but the interlinkage between party and state, if anything, is becoming more complex and certainly very different than, you know, the mid-1980s, where you actually had a conversation about should you have, you know, the Dangzheng Fengkai, actually some sort of, if not complete decoupling, at least loosening. So this is going to be something we're going to keep grappling with. I also want to say that I saw that Mark Cohen just put up a nice, great discussion of IP in the chat. So either encourage people to read his contribution in the chat, or perhaps we can get him on in addition to, I know, Don and Sophie too.
One question is, it's not only the party placing its units in the government and controlling it, but we see an expanded effort to put party units in every organization in China, including law firms. And it raises the question, when you have a party unit within a corporation, whether you call it Huawei or some ordinary state-owned enterprise, what does that mean in terms of their criminal liability? And it's always a troublesome question of what is a corporation's criminal liability. The other question is this general atmosphere that the government, our government, has been generating. Does it affect how US judges and juries will act, even if in principle and in practice, the Department of Justice insulates criminal prosecutions from the broader federal anti-China policies? Is this whole atmosphere likely to affect the outcome of whether there is reasonable doubt or not about the accused person's criminal responsibility? I think back to the famous or infamous Rosenberg trial of 1950 or so, when the question was whether the Rosenberg should get the death penalty. And the controversy over the federal judge, Kaufman, I think his name was, and his decision that the death penalty should be imposed in their case. And of course, the atmosphere, and I remember it personally in 1950, couldn't have been more hostile in the country, and the fear behind the hostility was huge. And there's always the danger that that affects the determination of whether there's guilt beyond a reasonable doubt and what the punishment should be. Do you want to say anything about that, Maggie? Or
yeah, no, I would just, the one thing on that again, so Mara Histendal, who's written this book on this case with Robert Moe, there in that case, it ended up not going to trial, but the judge had actually made a determination that limiting the references, I mean, obviously he was ethnically Chinese, but limiting references to that fact if it did go to trial because of concerns that it could be problematic with respect to the presumption of innocence. So I think this is something we need to be very aware of, and it's becoming more acute as COVID-19 has unfortunately brought to the fore a lot of not just anti-Chinese, but more broadly anti-Asian sentiments.
It raises the question of to what extent guilty pleas are made because the defense lawyer and the defendant take account of the likelihood of acquittal in a very hostile atmosphere induced by the American government stimuli of the media, et cetera. I know from my personal experience, it was hard in 1957 to convict a Marine of theft in the District of Columbia the day after Eisenhower launched the US Marines into Lebanon. And we had at best a hung jury. But a month later, people had forgotten about the Marines in Lebanon, and the jury had no trouble reaching a unanimous verdict of guilt because it was an open and shut case. And I remember in 1960, when the House Un-American Activities Committee led some of my Berkeley students to protest on the San Francisco courthouse steps, and they were prosecuted. I asked the defense lawyer in Oakland, one of the best, what are the chances that they'll get off? And to my amazement, he said, it all depends on US relations with the Soviet Union. He said, if there's a détente at the time of the trial, they'll likely get off. But if things are hostile, they're gonna fry. So this whole broader question of the atmosphere and who's responsible and what you can do about it is a hugely important, persisting one.
But I had this question for you, Maggie. You know, there's lots of civil and administrative disabilities that are imposed on people with even weak or indirect ties to the party state. And these are things like inability to get an F1 student visa, inability to enter the H-1B lottery, inability to invest in the United States because of CFIUS, inability to participate in a US grant program because you took money in the Thousand Talents program, and the list goes on and on. And none of these civil and administrative disabilities are really covered by the the criminal law logic or the theory of criminal law that you discuss in the paper. They're not part of criminalizing China, but they are part of penalizing China. And I'm wondering what you have to say about those. As the sanctions become less criminal and more civil and administrative, is it okay to say to the so-called panda hugger, guess what, you're not going to get a US grant? Or say to somebody who's worked too closely with NYU Shanghai, you know, we're a little bit worried about you and your security clearance. Is that okay? Is there an inverse relationship between the severity of the sanction or the criminal nature of the sanction and the breadth? Or put in the phrase you used, small yard, high fence. Can the yard get bigger as the fence gets lower?
Yeah, no, that's great. And I think, you know, when I'm teaching criminal law, one of the first things I'm thinking of Star Wars, I tell my students is you must unlearn what you have learned. You're not in torts anymore. We're now taking away people's liberty, not just their money. And so I do think there is a qualitative difference when this turns into a criminal prosecution. And particularly these are pretty serious. This is, you know, years could be behind bars. So I do think that not just the severity, but also the nature of saying you are a criminal has a different taint than saying, well, you can't get a certain visa, or under CFIUS, or, you know, now FIRMA, that you can't invest in something. So certainly I would think those are kind of more akin to collateral consequences that we see perhaps flowing from a criminal conviction, but not as severe. So that does matter to me. But you raise a good point that we need to also be concerned about all these other ways that we might be over deterring, over incapacitating, or perhaps they are hitting more the sweet spot in figuring out on the civil side or administrative side that this is actually the zone of people who should not be able to access this kind of visa, or should not be able to access this kind of investment. And in which case, perhaps there's some lessons that could be learned within the government, because, you know, this tends to be quite sort of stovepipe, siloed, pick your cylindrical object where there's not a lot of communication. Because one of my concerns is that the Department of Justice is not the part of the US government that has the deep country expertise. And I have not seen that there's great communication, or perhaps any, with, for example, people in the State Department who know more about China, and even within the Department of Justice. There's the Office of International Affairs, which does more with mutual legal assistance and whatnot, but I haven't seen any role there. There's sometimes prosecutors who speak Chinese. So I think, you know, perhaps, you know, those could be concerning, but I'm less concerned than when the full hammer of the criminal law is coming down and it doesn't look like the people in the room are necessarily thinking through, perhaps even as carefully as some people on the civil side who might have more of that expertise.
I'm happy to talk about academic freedom if you want. Instead, I've got a question that sort of speaks to a point that Jerry made earlier, and Maggie, in a way you were just touching on. I will reveal once again my ignorance. I'm not a lawyer or a law professor, you know, but I really sort of sat up and was very alarmed by the statement in your piece about DOJ deciding that, you know, that attorneys general across the country should go out and look for these kinds of cases. And I'd just love to hear you talk more both about, you know, the extent to which you think these cases actually have real legal merit, and whether they would be pursued if, you know, the people who were considered suspicious were, I don't know, Australian or French or Canadian or, you know, any other nationality. I mean, what would these cases even rise to the level of attention? And, you know, what would we look for just for merit, for actual legal integrity, as to the extent that we can detach these from a political agenda?
Yeah, and this is a known unknown, because prosecutors in the US operate within not a totally black box, but it's pretty opaque. And this is discussed by scholars all the time, totally outside of this context, about how the decisions that are made by prosecutors about what cases to bring, you know, what charges to bring, is subject to a tremendous amount of discretion. So there have been attempts, and I cite a paper that was a journal in the Cardozo Law Review a few years ago, trying to figure out, are cases, for example, with people who have Chinese names as the best proxy because it's not coded for their DNA or their passports necessarily. Are they prosecuted at a higher rate? Well, we don't know, because the whole point is others haven't been looked at. Are they given more severe sentences? There's some indication of that, but that could be explained, like perhaps these though were IP thefts of greater value or greater severity, so that those higher sentences are warranted. So I do think it would be helpful to get some real criminologists on this to be able to dig in, but they probably won't be able to say that exactly. I would recommend Harvard Fairbanks Center has a great podcast series, and they just had James Mulvin on talking about these issues, and he has been on the inside in the government and now outside, and he's very thoughtful in saying that listen, these cases are going on, again, this is not making it up. But I think part of it is we don't know how deep it is. And even if the cases aren't brought, this can have huge impacts on people's lives. And so it's not just the actual prosecutions, it's that more the specter of the threat. And, just deep down, as soon as you call it the China initiative, you're saying China's the threat. And I've been unable to find an equivalent initiative that had that framing of a country as saying, certainly there's been times, remember after 9/11 or other times that people of certain, ethnicities or religions or whatever it might be. And Jerry brought up some examples from, back in the day when the USSR was the threat. So it's not totally new, but it's sort of the latest incarnation of that. And I think it's being done in this really sort of heavy hammered way that is going to have a lot of negative externalities, as well as perhaps, the problematic nature in these individual cases.
We know the Department of Justice is highly politicized. We know that the exercise of prosecutors' discretion is supposed to take into account various factors, but it doesn't mean they should take into account certain factors that should be deemed unacceptable. We see this question in Hong Kong with the current Department of Justice in Hong Kong. Are they making government-inspired decisions to prosecute cases that might otherwise not been brought? We even see it in today's newspapers about New York not prosecuting burglars during the coronavirus problem because of the inability to guarantee their health while incarcerated. Let's have the next question, Alexis.
Do companies have to do what the government tells them to do? And here I think, Curtis Milhoff and Wentong Jung did a very good paper, I think around 2015, which basically argued that, state-owned companies aren't as statey as you think, and privately owned companies aren't as private as you think. And I think that's a really good way of thinking about it. And so the whole debate kind of over the ownership of Huawei, in a sense, is a bit of a red herring. The real question is, if you're a, big company like Huawei in China, and the government, agents come to your doorstep and say, do this, do you have to do it? Or can you say, no, thanks, we'd rather not? And they say, okay, just asking, have a nice day, right? So that's just my very brief comment about that. I think the focus on ownership can sometimes be distracting. I recently read two really quite good unpublished papers, which will be out at some point, about Huawei, which do it much better than I and my co-author did back a year ago. One of which in particular has the benefit of extensive conversations with Huawei officials about just how this kind of so-called employee ownership works, how the Employee Representative Council, how those people are nominated and stuff like that, which shows it really is a small group that controls Huawei, which of course is totally not a surprise to anybody. The other thing is on the Foreign Sovereign Immunities Act, which is a really interesting question, and whether you can get around it, by naming the party as a defendant. And I think really one of the problems here is the Foreign Sovereign Immunities Act, didn't contemplate, entities in which anything would be above the state. It assumed that the state would be the top, and therefore what it asked is, are you a state or are you an agency or instrumentality of a state? But what if you're actually above the state, like the party? Well, then you're not really an agency or instrumentality, right? And so I think it really, we need to think of state as kind of a broader concept that encompasses both a formal state structure, but also encompasses any other entity that has state-like powers, and the party, it has its own army. I mean, this is not just in reality, but it's also official doctrine, right? The PLA is a party army. And so I think certainly as a matter of, what the doctrine ought to be, it should include parties in one-party states such as China. Interestingly, there's a few cases on this, but none of them really none of them really address the question directly. There's one case in which the Communist Party of Cuba was basically assumed to be part of the state, but that was for purposes of holding it liable. That was not for purposes of immunity, and the court really didn't analyze the question at all. It just took it for granted. And then there's a case against the Zimbabwe African National Union, PF, which was Robert Mugabe's party at a time when it was effectively, the single party dictatorship. And in that case, it was found, again, without any analysis, not to be a state. And so but they never showed up. So they defaulted. But they didn't get the benefit of any analysis of like whether they were in fact a state or not. And presumably the court didn't think it was even worth talking about, because under the Foreign Sovereign Immunities Act, it's not an affirmative lose it or use it defense. It's an independent subject matter jurisdiction matter that the court has to figure out on its own. Okay, so that's just all I wanted to say about that.
It's really interesting to think about, yeah, exactly. The party and the party state, certainly as we go into our election season, it's very different than the DNC or the RNC. And I think sometimes, it's hard when you sort of have been taught civics in a certain way to understand how that works. And so part of this is just educating people, I think, in the US government and more broadly, but also even if you could sue the party, what are these lawsuits really getting at? Because, it's like when, even before the China initiative, when there's been indictments brought against PLA, People's Liberation Army officials or connected people who are in China, of course, they're never actually going to be brought to the United States and tried, but the signaling and the expressive function. So with the suits in Missouri and elsewhere as an expression of frustration and anger towards China. But I would be surprised if anyone really behind these suits expects that any money, maybe they do, is actually going to come from this, but rather, the other goals or just general, venting that is behind these. But maybe, I don't know if Don or others knows, maybe people actually think they're going to get something monetary at the end, but I think it's a much more based on the expressive function than the goal of actual dollars and cents.
Good afternoon. This is Elizabeth Donkerfort. I'm the China Program Director for IRI's China Program. Thank you very much for this chat. I'm a recovering lawyer now working in programs, and so it's been nice to sort of put my legal brain back into action. But my comment relates largely to some comments you made with respect to what this initiative, the China initiative, is including and how it's conflating different elements. And in particular, your comments regarding the collectors. And you mentioned that the party state has been, one of the things they do is pulls on the heartstrings or the nationalism of Chinese and the diaspora. Another element of this too is they're not just pulling on the heartstrings. Often they're using, not often, but there are incidences, and not a small number of them, using threats and coercion of Chinese diaspora or people who have what I call vulnerabilities in China, whether they're financial, familial, friends, whatnot. I'm not sure if there is really a legal remedy that we here in the United States or in other countries could take to address that issue, but I do see that something like this initiative really puts these people in an extremely difficult situation, because on the one hand, they are being coerced, threatened on the Chinese side, and on the other hand, they could potentially be facing criminal charges in other countries. And so I was just interested in other people's sort of thoughts on what remedies we might look at, but also your take on what is the risk for these people under this initiative. Is this level of coercion something that would be recognized either in the exercising of prosecutorial discretion or in sentencing or whatnot. Thank you.
No, it's a great point, and sort of that there's carrots and there's sticks. There's 1,000 Talents program, others that's giving carrots in the sense we'll give you money, we'll give you a fancy lab to work on back here, whatever honorific titles. But there also are sticks when people have these sort of vulnerabilities, or they, financial and particularly familial ties, and certainly Jerry and I have seen so many examples. For example, where there's people who their families are being punished for their behavior. You see this with lawyers in China who sometimes this sort of guilt by association. As far as how that would play in the United States, it's certainly not as an explicit factor saying we will understand that you're doing this because, of course, that I don't think it would rise to any level of recognized duress, for example, as a defense. I think that it should be more thought about on the policy side. So, for example, as I mentioned, the DOJ is saying, they are starting to have more conversations with academia. Part of this is talking about, and also with NIH and some of the big government grant makers, about being much clearer and also enforcing disclosure requirements, trying to get norms in place. But I think part of that conversation should also be how, in having these norms for how we go about making sure we understand where people are getting their money from, when they go places, why they're going, how can we also perhaps build in better safeguards, and whether that should be to ability to extend visas or stay longer, because the threat that at any point you might be told to leave the US makes it so there's this sense of constant vulnerability and lack of security. And so that strikes me as something that would be less of a factor in individual prosecution and should instead be more about the holistic, how do we create an atmosphere that keeps the people here who are helpful and contributing. And I end my piece with a quote from Yang Chung, who's a great writer, but she's a particle physicist in her main job. And that's exactly the kind of person that we're lucky to have her working in the United States on particle physics. So like, this is important, but that's a point well taken.
There's so many ways that the government can informally increase the climate of fear, uncertainty, and unpleasantness that scientists and other experts and talented people from China experience in the current circumstances. Questioning is very important. Just selecting somebody and sending the FBI around to interview them, especially when there's a danger, if you're deemed to give a false answer to a government official, you'll be prosecuted. As Martha Stewart discovered. Also, the threat of prosecution if you don't cooperate. And the knowledge that the prosecutor can, as Maggie points out, select among or all of a horde of different offenses, each of which may have different punishment and consequences, and know that there could be almost a coerced guilty plea in order to get a lesser punishment. Finally, there's this question of the relationship not only between the president and the attorney general, who currently seems to be just wagging his tail whenever the president asks, but what's the relationship between the attorney general and the US attorneys in different areas? At some points, there have been differences of views between the attorney general and certain US attorneys in various places over whether to call for the death penalty, for example, in a given case. Here it seems to be assumed, and it may be politically the right assumption, a US attorney who doesn't do what the attorney general tells him in terms of meeting the quota for prosecuting in accordance with the China initiative could well be subject to removal. So there's just so many questions here, and it raises again the question we start with is, what is to be done and how to do it? And Maggie's article is a welcome first step. It won't be out till December, And then how does the law review article reach the broader public? And of course, we could get it to the public much sooner. It's already there because of SSRN. And what should we make of it?
Yeah, and I would just point out that the small kind of the the leading group for the China initiative does have several of the U.S. attorneys, and the ones it's from. So District of Massachusetts, so Lelling, who's been up there very in the forefront with the, for example, Professor Lieber case at Harvard. Then also though, Northern District of Alabama, Northern District of California, Eastern District of New York, and Northern District of Texas. So it is pretty diverse geographically. And as I said, the FBI and DOJ more generally has emphasized that this is done across the US. All 56 FBI field offices have active investigations. All the US attorney's offices are looking at this. So this is not just in a few hubs. This is seen as a comprehensive effort.
Maggie, are there any specific examples of so-called party state individuals who are engaged in IP theft or suspected to be engaged? And second of all, do you know the Chinese law on IP theft and whether there have been any prosecutions under it?
I might leave the second one to Mark Cohen if we get him back on. And no, but certainly, there's, you can have an under Chinese law, but I don't get the sense that there's anything equivalent as far as worries that the US government is on some sort of large scale encouraging, incentivizing, sponsoring theft within China. With respect to the first point about actually people connected directly to the PRC party state, I mean, certainly before the China initiative, sort of the banner for that was the 2014 indictment against those 5 people connected directly with the PLA officers for cyber intrusions and economic espionage. And that got a lot of attention. And now more recently, it's more prosecutions of these non-traditional actors, people who are in businesses, people who are academics, even concerns, about students. So less of this, there are some of the indictments that include people who are party members, that's flagged, who still have some sort of role in the party. But again, sometimes it's hard to tell when you have approximately 90 million members of the CCP, and I see an indictment from DOJ that mentions a tie to the party, whether it's a strong tie where they're working for the party, or if they're one of these many millions of members of the party that probably don't even go to their meetings as much as they should. So that's hard to tell, but there have been examples where there are people directly working in the party state, yes.
Mark Cohen is back with us if we want to get him in on this question of the extent to which theft of intellectual property is a crime in China and whether in practice it is punished.
I'm happy to answer that if that's an abiding question. The reality is that in terms of China's criminal docket, which is predominantly trademark related, a little bit of copyright, and even less trade secrets, it's now at probably about 12 to 14,000 cases, probably around 20 times the size of the US docket in terms of criminal cases. The civil docket, which is predominantly copyright, but includes everything, is up to about 490,000 cases. They calculate cases a little differently, but that would be roughly 50 times the size of the US docket. The criminal trade secret cases, both in the US and China, which is at the core of this kind of IP theft narrative, are relative outliers in that overall docket. They're notoriously difficult to prosecute. There's a great study, I think, done by attorneys at Morrison and Forster, if I'm correct, who looked at success rates in US courts on trade secret cases, civil trade secret cases. It was the lowest of any IP right. And similarly in China, you have a very low success rate. So there's this kind of and as I mentioned in my written comment earlier, there's this tendency to over-criminalize trade secrets as a consequence. That's particularly true of civil jurisdictions because they lack discovery. You can't get the evidence, so it tends to go through the criminal process. And you do see in China, companies like Huawei and ZTE and Shenzhen really using the criminal process in lieu of what would otherwise be adequate civil remedies. In other words, employee leaves your employ, takes trade secrets with them, and normally you would do that through the civil system, but since they're so well connected with the police, they go through the criminal system. You also have this really interesting parallelism between the US and China, where the US is pursuing these kind of conflict of interest, conflict of commitment cases like the Harvard biology professor and some others, because, and having failed in the physics case at Temple and others, because these trade secret cases are difficult to pursue. And I think what it really is missing from the public discourse is that incredible difficulty. You basically are having a patent case without the patent. You have to prove the existence of a technology that is valuable, that is not in the public domain, and prove that it was misappropriated and you didn't take appropriate reasonable steps. And then you have the added problem of willfulness in the criminal system. The consequence is that prosecutors in the US, the way I see it, are increasingly going to non-economic espionage claims. Just like in civil cases, they frequently go to the non-disclosure agreement or the non-compete agreement because it's much easier to prove than the trade secret misappropriation. The other point to add in here, and this is, I have a real problem, and I know Maggie, you use the term IP theft, sometimes I lapse into that. I have a real problem with it because this is a private civil right, and the primary remedy should be civil. And when we talked about IP theft 15 years ago in the US, it was overwhelmingly trademarks and copyrights. It wasn't even about trade secrets, and it's certainly not about patents. We don't criminalize patent infringement in the US, and most countries do not. When we negotiated the TRIPS agreement, we didn't require that members criminalize trade secret infringement either. Even before we got involved in this whole FBI discussion, in our FTA agreements with Singapore and others, we were saying you need to have an available criminal trade secret remedy because that was something we left out of our trade discourse. So to me, the narrative about criminalizing China, absolutely agree with it, but the other kind of narrative that I see from my frog in the well perspective is about criminalizing IP and losing perspective over the importance of the civil remedy and how it works.
You need to chat with my colleague, David Opterbeck, because he totally agrees. And he hates, like, what's this with trade secrets that are, and economic espionage only became a federal crime in 1996. Yeah. So this idea that trade secret theft gets risen to this level where if it's for the benefit of a foreign government or an instrumentality that we've enhanced it. And that's not, 24 years ago isn't that long ago. So one more thing with respect to this, of what are the charges that I went through the indictments and some of the other common charges that are brought are, the mail fraud, wire fraud, false tax returns, making false statements, obstruction of justice, violation of Foreign Corrupt Practices Act, computer hacking, international money laundering, exactly all those things, like Jerry said, that can come along from the interaction with the government officials. So the actual plea agreements often are not for an IP theft or economic espionage. They're for something like false statements or obstruction of justice.
It would also be good to know to what extent prosecution is suspended or prosecution is ended on condition that certain civil remedies or responses to other US government demands of a non-criminal nature are made, as so often happens in other criminal cases.
There's a really interesting twist on that, and Maggie, you mentioned briefly the Huawei Tappy case. Mm-hmm. And that case is really interesting because the court in the prior civil case, the jury decided, yes, it was trade secret infringement, but no, there were no damages. So that was at best a Pyrrhic victory for T-Mobile, perhaps none at all. But after DOJ announced its latest initiative or whatever, or second initiative, whatever it was, they went ahead and they reopened that case and said, now we'll bring a criminal case. So normally you don't bring a criminal case if there's an adequate civil remedy. And here, you could argue there was an adequate civil remedy or it was inadequate because there were no damages, but that just shows the willingness of DOJ to open up cases, notwithstanding the availability of a civil remedy.
Thanks for bringing this topic to everyone's attention. I just want to point out, I mean, a lot of the conversation we've had is about China and how to deal with China. And I think your point you started with maybe getting lost a little bit. This is such an aberration for the Department of Justice to single out a single country and identify a initiative as being related to that country. In fact, it seems to be in violation of the Department of Justice's own justice manual and the principles of federal prosecution, which has a section on impermissible considerations in deciding whether or not to bring criminal cases. And one of those impermissible considerations is national origin. And here we have the Attorney General and several US attorneys and the head of the FBI publicly calling out people of a particular national origin for scrutiny under the criminal law. And it's outrageous, and it just shows how inured we've become to the violation of norms under this administration. Not a single person apparently in the Department of Justice said, wait a second, this violates our own internal guidelines. And as Mark said, another consideration under principles of federal prosecution is whether or not there's an alternative remedy short of the criminal justice system. The criminal justice system should be a remedy of last resort. So I think because China has very few people in the body politic in the United States who will speak up on behalf of China, that this policy hasn't really been criticized. And it's unfortunate because it's another step in politicizing the Department of Justice. And if you're sitting on a jury in a case like this and the defense is, my client has been singled out because of their national origin, that argument seems to me would have some validity. So before we close, I just want to, as somebody who spent a lot of years in the Department of Justice, I just want to point out how far this is from how the Department of Justice used to view its role. And in my opinion, what the proper role of the Department of Justice is. That's all I wanted to say.
Thanks, Ira, and I'll leave it there with just one comment that takes me back, as I quote from in 1880s, the famous Yik Wo case about selective prosecution. And there, Justice Matthews wrote that the rights of the petitioners as affected by the proceedings of which they complain are not less because they are aliens and subjects of the Emperor of China. And of course, that was the Emperor of China because it was the 1880s, but it's not a good thing when we're looking back at cases from that far ago as the warnings of what happens when we put ethnicity and national origin as considerations.
I think Ira's statement is very important, and it raises this troublesome question of selective prosecution for whatever reason, ethnicity or ideology or what. And this comes up, of course, in the forthcoming trials of Martin Lee and the other Democratic figures who've just been singled out for prosecution because they took part in and apparently helped in some respects organize some of the protests of last year in Hong Kong. Well, I just want to say this has been a successful, terrific discussion, as good as we anticipated in inviting Maggie Lewis to join us. I hope we've started to agitate people sufficiently to start ventilating in public about this. It isn't good enough just to talk among ourselves, but I hope this will generate some thoughtful op-eds, short essays, and various media letters to the editor and whatever, because this is not yet a sufficiently visible issue for the American people. Finally, just a word, next week's discussion, which I mentioned at the outset, that we'll have with Steve Orleans about my memoir of the period Steve and I shared, 79, 80, 81 in Beijing, will take place not in the usual afternoon time, but at 10 o'clock in the morning. And this is a desire to reach not only the people in Europe, which we can reach at 2:30 in our afternoon here, but also people in Asia. And I hope we'll get some of them to take part. Thanks, Maggie. It was a great show.
Thanks, Jerry. And thanks to Alexis and Kelsey and everyone behind the scenes at US Asia Law Institute. I've worked there and I know there's a lot that happens that you don't see on the surface.